Welcome. My name is Darren Baker, and I'm an estate planning attorney in Orange County, California. I've been doing this since 1992, and I've seen all kinds of different situations that arise when people do this. Now, why should I do any estate planning? What is estate planning? Well, estate planning is when you decide to draft documents to handle your affairs in case you pass away or become incapacitated. Let me give you an example of a couple that needs good estate planning. I talked to a man who came in with his wife, and we were talking about their estate plan, and the wife asked the man something interesting. She says, "Honey, if something happened to me, would you ever remarry?" And he said, "Of course not, darling. You're the only woman I would ever love, the only person that I could be with. Of course I wouldn't marry." She goes, "Well, what if I wanted you to marry?" "Well, if I found the right person, someone who measured up to you, maybe I'd remarry." And the wife said to him, "Well, would you let her wear my jewelry?" He says, "Of course not. Why would I let her wear your jewelry?" "Would you let her wear my mink coat?" "No, I wouldn't let her wear your mink coat. That was personal to you." "Would you let her use my golf clubs?" And this is where he made his mistake. He said, "No, honey, she's left-handed." That's a couple that needs to plan for some things because they clearly have different ideas about what's supposed to happen. Now, the main thing that people use when they do an estate plan is a living trust. And you've probably heard about living trusts. Someone's probably told you, you need to do a trust. Well, why? The reason to do a trust is very simple. There are other reasons, but the main reason is to avoid something called probate. I love probate. I make lots of money in probate. But your heirs don't like probate, and they certainly don't like writing me a big check once the probate is over. When you're in probate, you're in court, and nobody likes going to court except for the lawyers. So why would I need to avoid this? Well, your kids are going to be waiting years, potentially, to get your estate if your estate goes to court. And if you have a will, you have a ticket to probate. If you don't write a will, you have a ticket to probate. The only way to avoid probate and to avoid the thousands of dollars and years of time is to do a living trust. Now, a living trust is a document that basically says what happens to your stuff when you pass away, kind of like a will. The difference is a living trust does not have to go through probate. And if you follow the directions from your estate planner, nothing will go to probate that's in your estate. So what is it exactly, and what else does it cover? It's a document. It's going to be longer than a will. It appears to be complex, but it's really not. And it's going to cover not only your death, but it's also going to cover what happens if you're incapacitated. Nowadays, people spend an average of about 6 months before they pass away where they're incapacitated and unable to handle their own affairs. So we have to plan for incapacity almost as much as we have to plan for your death. And a trust is a document that will name 3 kinds of people to handle your affairs. And these people are very important, and they have titles. The first person is called a TRUSTOR. He's also called a settlor. A settlor or a TRUSTOR is the person who creates the trust. That would be you. And only the TRUSTOR can change the trust or cancel it. It's a revocable trust, which means you can change it when you want to. You can cancel it if you want to. That doesn't happen very often, however. The second person that's important in a trust is someone called a trustee. A trustee is the person who carries out the terms of the trust. Now, since this is a living trust, we're going to have a trustee while you're living. And who better to handle your own affairs and your own assets than you? So you will name yourself, or you and your spouse if you're married, as the trustee of your trust. The last group of people, the best group of people to be, are called beneficiaries. Beneficiaries get to live in the house and spend the money and drive the car and take the trips. And of course, who better to do that than you or you and your spouse if you're married? So those people are important, and while you're alive and competent, that's going to be you. So what happens if I'm a married person and I do a trust? You're going to do a trust together. It's going to be a joint trust. You're going to name each other trustees, And there will be provisions that say what happens when one of you passes away or becomes incapacitated. Mainly, all that it's going to say is that the surviving spouse is just going to pick up and handle things by him or herself. There will be a little paperwork we do when the spouse passes away or becomes incapacitated, but for the most part, it's a very smooth transition and the survivor just keeps going. If you're single, the trustee is going to step in when you're deceased or incapacitated. That's probably one of your children. If you're married, when the surviving spouse becomes incapacitated or deceased, that's when we'll have the next set of trustees. And again, those are usually your children or the beneficiaries in some order. And they're going to do what the trust says. The trustee, after you're deceased, cannot change the trust. The trustee cannot do whatever the heck they feel like. The trustee has to do what the trust says. Well, who's going to be watching the trust while this is going on? The other beneficiaries, because they want their money yesterday. They want to know why this trustee is taking all of 2 or 3 weeks to give them their money because they have plans for it. It's going to take a little bit longer for them to get their money, but not much longer. So the heirs are watching the trustee, and believe me, they're going to be real tough on this person. Being a trustee is not fun. It's not easy. It's a pain in the rear end, and you have to put up with all the whiny heirs that you're taking care of the money for. So let's talk about probate a little bit more, just so you know why it's so terrible. The average probate right now in California takes at least a year, and the court fees, attorney's fees, and executor's fees are going to gobble up about 8% of your estate. And that's 8% of the gross value, not the equity. So if I probate a $600,000 house that has a $500,000 mortgage on it, for purposes of my fee, I'm probating a $600,000 house, and my fee, as you can tell, is going to be a lot bigger than if it's a $100,000 house. The fees are set by the state of California and must be approved by a judge. But suffice it to say, even on a small estate, say a $300,000 house, the fees for the probate are going to be about $9,000 or $10,000. And that's for the lawyer and the executor of your will. Also, while things are taking time, people are getting upset. They want to know where their money is. The heirs are not known as a bunch of patient people. In fact, when I was in law school, we called the heirs the grubby group because their hand was out saying, gimme, 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 where's my money? I want it now. Well, in court, they're going to have to wait till the judge says they get it, and they're not going to be very happy. So probate is not a great thing to go through when you pass away. But most people don't know, if you haven't done any estate planning and you become incapacitated, you got to go to probate court in something called a conservatorship. Your spouse just can't automatically do things for you. And if you're not married, your children can't automatically do things. They have to go to court, and a judge can tell them what they could do with your assets. And you're going to be in probate court every year you're incapacitated until you pass away, and then guess where you get to go? Probate court. So you're going to be in probate for a long, long time. I've seen people who've been in probate for 20 years. It's not a good thing to do. Nobody's happy. A probate that lasts that long is probably not going to leave very much to the heirs because the fees are going to be very expensive. Now, when I have a living trust, what do I have to do to make it work? Well, first of all, when you sign the trust, you make it legal right by doing that. It doesn't get recorded, doesn't get filed away anywhere. It's a legal document that you have that's a binding document. But it's basically an empty box. It doesn't work unless you put assets into the name of the trust. That's called funding. Funding is the reason that most people who have a trust don't always have their assets in the trust because funding is difficult. Not very, but it's a little bit of work. But funding is important. If the asset isn't in the trust when you die, it might go to probate. So follow the funding instructions that your attorney gives you and put your assets in the trust. What does that mean? Well, when I do a trust for a client, I put the house in the trust. I do that with a quitclaim deed so that the house is in the trust. I also do that for any other property they may have. By the way, that house you have in Arizona, that's 2 probates if you don't have a trust. because you get probated in Arizona and you get probated in California. To me, that's a really nice vacation at the end of the year with my wife. So you want to avoid probate everywhere you have property. Get all your properties in the name of your trust. I can help you with that. Now, in addition, you have bank accounts, you have investments, you have IRAs, 401ks, all these things. For every asset you have, you're either going to, one, change the title on the asset, which means the trust will own it, or change the beneficiary to the asset, which means the trust will get it upon your death. Now, just because the trust owns it doesn't mean your hands are tied in handling your money. Remember, you are the trust. You have complete control over the trust. You can do whatever you want to do with the assets until you pass away. Funding is very important. I can't stress this enough. Get your trust funded. If you haven't done it already, go do it. Follow the instructions your lawyer gave you and get this done, because believe it or not, I've probated trusts before. Not trusts themselves, but the assets that were not in the trust when the person passed away. That's usually something like a house. The client refinanced their house, the lender took it out of the trust for some reason, and they never put it back in. Well, guess what? We have to go to court to get that straightened out when you pass away. So funding is very, very important. We'll make sure when we file the deed, when we have the deed recorded, that your property taxes will not change. In California and pretty much everywhere else in the country, if you're transferring your property to your living trust, the property tax stays exactly like it is now. There is no reassessment of your property. Also, pension plans, insurance policies, those kinds of things, they have beneficiary designations. If you're married, you're going to want the first beneficiary to be your spouse. The second beneficiary would be your trust. And if you're not married, the first beneficiary will be your trust. But we will give you copious instructions on exactly how to do this. We'll give you letters to take to the bank and take to your broker that tell them exactly what you want them to do. So all you have to do is sign a form that they give you, and that'll take care of putting the assets in the trust. So to recap, probate. A trust avoids the probate. A trust avoids a conservatorship, which is a probate when you're incapacitated. Your property taxes don't change. And in California, there is a benefit to holding community property in a trust. And that benefit is a big one. It involves capital gains taxes and a new basis. To put it simply, when you pass away, your property gets a new tax basis for capital gains purposes, which is equal to the value at your death. So I always tell the surviving spouse, if you ever wanted to sell your real estate or your stock or anything that's gone up in value since you've owned it, this is a good time to do it, and you're not going to pay any capital gains taxes on it. So take advantage of that. A well-crafted trust is going to do that for you. So in short, get a trust, save probate, save taxes, make it easier on your kids or your loved ones. Now, when you do decide that you want to do a trust or do estate planning or at least get some information, you can always call my office. The number will be on the screen. I'm a local person. I've been raised in Orange County all my life. But if you live somewhere else, contact a lawyer in your local area. He'll be most familiar with the laws in that area, especially if you're out of state. I can handle trusts and do trusts anywhere in California. I have clients that I've never actually met, but I've done their estate planning through email, faxes, the mail, etc. So if you're interested in getting this done or you want to find out some more information, call my office, and my assistant Blanca, who also happens to be my wife, she will be able to help you. So I hope this has been helpful for you. I'm attorney Darren L. Baker. Please contact my office if you have any other questions or if you'd like us to prepare your documents for you.